On that, please introduce our speaker. Hi, all students. Say hi to our speaker.
So, good morning, everyone. And today is our pleasure to have the guest speakers, Miss Suthirat. Okay, Miss Suthirat Yodingyuat, Miss Mathurot Piyachosukit, and Mr. Chinapat Visuthipat as our honor speakers to share the knowledge about the IP. Right? And so, you know, let's start here.
Okay, good morning, everyone. My name is Christy, and I am here together with two other members of my colleagues to give you a brief preliminary taste on intellectual property. The objective that I and my team have been assigned today is to introduce you to the various types of IP and how that would impact you as deep tech entrepreneurs. Many of you may already have some knowledge on what I'm about to talk about today. Many of you have experienced intellectual property all around you. For those who already know a bit more, then I hope that this will be a good brush-up course. For those of you who might know a bit less, then hopefully this will be a guide to your basic understanding of IP. Okay, now, why is it important to understand IP? I think we all touch on IP in every aspect of our lives. And whether it be, you can just walk into a supermarket and you see the various brands or various products that have the names of the company or the logos and things like that all on them. Even in a warehouse you walk in, there is some sort of technology that helps with arranging the product, how the products are taken out of storage and things like that. All of that is actually IP. You watch a movie, you go to the cinemas, you watch a movie, again, that is all embedded with various types of IP. So that is why IP is important. And moving forward, when there are, there is little left of other resources, probably IP or intellectual property would be a driving force to the business arena in the future. Okay, so let's start with, how do I start the slides? Okay, 12. Okay, so let's start with, yeah, that's the right one. Okay, I hope you can all see the screen that I'm sharing. If you don't see it, please let me know. Do you see the screen?
Yes, we do. Yes, we do.
Well, yeah. Okay. So let's start with what is intellectual property. Okay, you see many words thrown around and you listen to these kind of words every day. There's copyrights, there's trademarks, and there's patents, right? Now, all of these are together collectively called as intellectual property. However, they are not the only type of intellectual property there is out there in the world, okay? So let's look at what intellectual property is. Now, WIPO, which is the World Intellectual Property Organization, states that, intellectual property is the creations of the mind. Okay, so now here you see two main words. The word mind. Obviously, this refers to intellect, right? Anything created out of using intellect, it comes from the mind. Okay, now what about creations? Creation in itself means that there must be some sort of expression, there must be some sort of form of how this idea or how this intellect is presented to others, presented to the outside world. So that is why when you talk to a lawyer or a legal counsel would say that an idea is not intellectual property. You have the idea stays in your head. That is not intellectual property. It only becomes intellectual property once it's created and the outside world can make use, can see it, or can benefit from it. Okay? Now, talking about legal counsel, for a legal person, intellectual property is the product of human intellect that laws protect from unauthorized use by others. Okay? Why is it important to protect intellectual property? In terms of legal, intellectual property is something that is not, it's not as simple as just lighting a light bulb, right? It's not simply that you have an idea, you write it down on a piece of paper and you can get money out of it. No, it's not as simple as that. But once you have the idea, there is an incubation period or a sort of a road you have to take in order to make that idea more realistic or more commercial. Along that road, there will be some sort of investment along the way. There will be, you know, your hard work, sweat and tears. There will be money injection. There might be, if you are a scientist, you might have to go to a lab, do research, do experiments. Again, all of that costs money. So why is it that if IP is not protected, somebody else comes along and makes a fake or copies it? They didn't have to go down the road that you went, right? They didn't have to waste the same kind of resources, the time or the expenses. However, just by copying somebody else that has come up with this IP, they can actually benefit from it. So this is why the law finds that it is very important to provide a framework to protect people that have come up with these IP ideas, okay? In a way, it also motivates others to come up with other innovations or inventions. And at the same time, it ensures the IP creator that they will be able to fully commercialize that IP, okay? In terms of investment, IP is described as an intangible asset. So obviously intangible means that you can't touch it, okay? Whether it be a trademark, let's say we have Samsung. The name Samsung alone, if you look at its financial statements, the goodwill or the value in the name Samsung alone has a value, has actually quite a substantial value to it. Now, where is this Samsung? Can you touch it? No, you can't touch it, it's intangible. So the same goes for other types of IP. Unless you're talking about an invention, let's say you're an engineer and you invented something like a conveyancing belt that could fly into the sky or whatever, then that might be tangible. But most of the time, intellectual property is intangible, okay? So that's why in terms of investment, IP will be defined as an intangible asset that is owned by the creator and legally protected from unauthorized use, okay? I hope you're all following and you haven't fallen asleep. I'm thinking that this is the first class today and you shouldn't be sleepy today, okay? Now, let's go through the various types of IPs there are, okay? I will be touching on briefly all of these types of IPs so that my objective is that you can then hopefully distinguish different types of intellectual property that you experience in your life. And once you can differentiate or you can categorize these IPs, you will then know how to manage it, okay, for your commercial benefit, okay? So let's start with copyright, okay? Copyright is something that is defined as, simply put, it's literature and artistic work, okay? Let me give you more examples, but basically literature and artistic work is what defines copyright. let's start with written works, okay? With written works, novels, okay? You've all read some sort of novel, or you've read a cartoon book. All of these things have copyrights in them. So copyright is the form of how the story is presented in that novel, how the cartoon is drawn, how the storyline goes, and things like that. All of that is a copyright in that novel or in that story. Okay, then we have things like brochures, brochures or pamphlets. Okay, sometimes you go to a pharmaceutical store, a drugstore, and you buy a certain drug or a medicine. In the box, you will see a pamphlet or a brochure that explains how that medical device or that drug is used. Okay, now all of that context in the brochure or in the pamphlet, that also has a copyright. So whoever wrote that brochure or pamphlet owns the copyright of that piece of writing. Okay, then we have presentation. Just like the one that I'm doing for you today, this presentation is my copyright. It's how I arranged these words and presented it to you in this format, in this color, and all of this together combined is my copyright in this presentation work. Then we have articles. Whoops, I'm sorry, I keep dropping things today. So with articles, I'm sure that as a student or as a faculty member in the university, we've all written articles, right? Whether it be regarding research, various news articles and things like that. Now, how we choose to arrange these words to try to tell the story that we want to tell to the outside world, all of that combined in that article is a copyright, okay? And the copyright belongs to the one who wrote it, okay? So this is an example of literature, okay? Then we have music compositions. Music compositions is the arrangement of the notes and the lyrics, okay? So when you think of a song, there are many, many parts to a song. But the basic part is the arrangement of notes, do, re, mi, fa, sol, la, si, do, and the lyrics that go in it, okay? Now, for a song, there might be more than that. There might be something called a mix, a recording. How that song is recorded is also another copyright, which is separate from the melody and the lyrics. So in a song, there are various types of copyrights that go into it, but the most fundamental copyright is the melody and the lyrics, okay? I was talking about the recording of a song earlier. So sound recording is also another type of copyright, which, as I said, is separate from the melody and the lyrics. So how it's recorded, whether it's recorded in a certain tempo, under a certain beat, it might be a dance version, it might be an acoustic version. I'm sure all of you have heard songs that are acoustic, bossa nova, EDM, or mixed, dance remixed, or things like that. So that is the recording of it. And that in itself is a separate copyright. Then we have paintings and sculptures. This is easy, an expression of art. So paintings that you see on the wall, you see various sculptures, 3 dimensions, you see photocopies, photographs, okay, by the photographer who, maybe there are many people shooting or photographing the same thing, taking a photo of the same thing. However, each person taking that photograph has the copyright in their own photo. So let's say, for example, I go to Slogan Park, okay? I take my iPhone with me and I start snapping shots. Another person going to the same park, Lumpini Park, snapping the same shot, they will get a different photo. there might be some elements, the lighting, the elements, how that, how each moment is captured will be different. I will have the copyright to the photos I took, and they would have the copyright to the photos that they took. Okay, so that's an expression of art. Another example of copyright is film. So we watch films, we watch television every day. Okay, now film is actually a recording of visual moving images. Okay, again, in a film or in a movie, there are many copyrights. There is also how the film is produced, how it's on what kind of material or on what kind of film. Again, that's a separate copyright for each and every material. How the soundtrack is. So the soundtrack, again, it goes back to a song. So a song already has many copyrights in it. Okay. Any questions so far?
Yes.
Okay, Ka.
Okay, Ka. This is very interesting because our students use all kind of media in their presentation a lot. And sometimes they don't understand. Even I'm not very sure about the copyright, because you said the copyrights happen in itself. That means it doesn't have to go through, like us, we have to write the patent, we have to ask for the approval, so the patent belong to us. But all the copyright, as long as you show it to the public, it becomes copyright right away. Is it correct?
You don't even need to show it to the public. A copyright, the right is created upon creation. You instantly have the right once you've created that piece of work.
It's very interesting. The reason that is interesting because when we do the patent, there's a lot, because it takes a lot of time for us to do a patent. So
yes.
Two person in the world might think about the same thing, and then they have time to develop the same thing. Okay, but if the copyright happen when you create things in terms of literature and arts, it happened right away when they start to sculpture something, right? So they have a right to when they show in the internet, they have copyright right away. So if somebody took it without saying that this is belong to who, so you kind of against the law right away. Is it correct?
That is correct. Now, I will later on talk about a term called fair use. Now, fair use is a legal concept, and basically it provides a sort of exemption for various kinds of usages for copyrights that would not be deemed infringement. So when you violate somebody else's copyright, we call that infringement, right? So you're violating, or you're taking the product or the copyright of someone else's and using it without their permission.
Okay.
Now, the fair use.
Yes.
Yeah.
So the students have been using media, pictures and video in their presentation a lot. So I would like you to kind of give them, the what you call it, the caution after this. Thank you very much.
Okay. Okay, Ka. Now, as a student or even as a faculty member, we do these presentations, and obviously, yes, we would like to make the presentation more spicier, more motivating, more enticing to those that watch it, right? So we will then put in pictures, and with these new age programs, you can take pictures from the internet, you can download it from your own pictures files and things like that. However, if you do take things off the internet, which is something very common nowadays, first of all, you have to look at why you're doing that presentation. Is that presentation purely for academics? If it's an academic piece of work and you're not using it to gain any profit or any sort of remuneration, then that use is under fair use. It will fall under fair use. So in that case, even though theoretically you might be infringing, but there is an exemption there. So you can use it. Let's say, for example, I am in a marketing company. I'm a trainee in a marketing company, and my superior has asked me to help with a presentation, a PowerPoint presentation. So I pull in a song, I pull in some videos from YouTube. Now, because I'm a student, does that fall under fair use? The answer is no. It's not about who you are, but it's about what you're using that IP for. So in that presentation, obviously, you are a trainee in a marketing firm. The firm will use that presentation to go and pitch to a client, right? So obviously, that is for a profit, that is for commerce. The minute you do that, if you do not receive permission from the authorized or the owner of the copyright, then you are deemed infringing someone else's copyright, okay? Now, your response might then be, but everyone does it, right? Which is a common saying for everyone nowadays. Everybody does it. The majority of people do it. The fact that the majority of people do it and the fact that everyone else out there is doing it does not make it right. The law is the law. The fundamentals are there. Infringement is infringement. Why do we not see many cases of people suing each other for infringement of copyright? Sometimes it's just not worth it. Would it be worth it for Ariana Grande to sue a trainee in a marketing firm just because that they had took a video clip of her dancing in Fortnite and put it in the marketing firm's presentation? No, obviously not. She might not even know it for starters, okay? But knowing that how well these copyright licenses work, the video will come with an embedded source of sorts. And it could be easier for them to track, but whether or not they take action against that student or whether or not somebody wants to take action against you is another thing. They would think about, is it economically reasonable to do so, okay? So I hope that in a way, I'm not saying that because you're a student and because it's for academic purposes, you can do whatever you like. I'm just saying that you still need to be careful and you need to ask yourself each and every time that you are using someone else's work, whether you are going to gain any profit or commercial benefit from this, okay? I hope that answers your question. Great. The next example is computer programs. So here we have a lot of software out there in the world, and all of these softwares or computer programs or how hardware is set up to work, they use a set of instructions, and the hardware then takes on these set of instructions and operates or executes certain things according to that set of instructions. Now that computer program is a copyright. There are, I think, the number of computer programs that are being registered nowadays has increased substantially because not that people come up with new codes or new set of instructions every day, but most of it are add-ons, something that is added on to an underlying IP that is there already, but they add on and do different functions, serve different functions. And the amount of copyright notifications that are being sent, especially like in Japan, is certainly on the rise. Oh, and in South Korea as well. Okay. Then we have maps and technical drawings. I'm not sure whether any of you have gone into this section of a bookshop where they sell books about traveling. You might find Lonely Planet kind of books, you might find Time Out kind of books, and then there are maps, right? Now, there are maps that explain the Jatujak market. There are maps that explain the various restaurants in Yaowarat. There are not only can you download them on the internet, there are blogs and websites that also provide, but there are printed copies as well. Everything there that is a map, you know, telling you what good things there are on this road, or what kind of souvenirs there are in this area, or the touristy places in this area. All of that, actually the creator of that map owns the copyright in that map. Okay, technical drawings, obviously technical drawings like blueprints, all of these have copyrights in themselves. Okay, so as I was saying before, a copyright, the right to a copyright is created upon creation. Why? Because the law deems that you have already expressed, you've already expressed or created that that piece of work. Okay. Does copyright need to be registered? The answer is no, because the right is already there upon creation. However, there is a means in which you can protect yourself by claiming that this was the date, the official date that you created this to the outside world. And that method is called notification of creation. You do this by, when I was younger and learning IT in school, my teacher used to say, put it in an envelope and mail it to yourself through registered mail. Okay, so you have the evidence of when you put it in the envelope, when it was sent to you and things like that. That is a cheap way and effective, as long as you keep the evidence of that sending or the post that you sent to yourself. However, there is also an official way that the Department of Intellectual Property provides, which is they allow you to notify them that, oh, I've created this piece of work. So there is, it's not a registration, but it's a formality whereby you inform the authorities that you have created this copyright and you own it. Okay. Now, the protection of a copyright is throughout the creator's life, plus an additional 50 years after the creator has died. So let's say, for example, the Beatles song, okay? So the Beatles is a band, right? And they together have written and performed many, many songs. Now, a question might be, oh, because the band has 4 people in it, so what's the period of protection in their songs? Well, the period is this: after the last member of the Beatles has died, then you count on another 50 years. Okay, so that would be the span of protection for a copyright. So, moving on. Okay, moving on, we have trademark and service marks. Many of you have heard of the term trademark, I'm very sure, but some of you might have never heard of the term service mark. Okay, now the name itself is quite explanatory, right? A trademark or a service mark is basically a mark, whether it be a designed word or a drawing or some form of color that is portrayed on a certain material that can distinguish one person's product or services from another person's product or services. The term trademark is used interchangeably. Everything that distinguishes one business from another person's business is called a trademark. But actually, in its roots, the word service mark is typically used only to identify the business or the service provider. Let me give you an example. Okay. Here, everybody should know what this is, right? Okay, this is the Apple logo. Now, Apple is something that they don't even have to spell Apple. We look at this and we know instantly which company, which Apple we're talking about. Okay, so this is a trademark. Now, also within Apple, there is the iPad, there is the iPhone. All of those are trademarks as well. So Apple is registered actually not only a trademark, it's also a service mark. okay? Because it provides services, it provides after sales, customer services and things like that, okay? So iPad, iPhone, iPod, if any of you were born in time for the iPod, all of those are trademarks because it distinguishes a product, okay? Then we have Thai Airways. Thai Airways, or even if without the word Thai, just the logo in front, that Thai flower in front, which resembles an orchid in purple, will tell you that this is Thai Airways, okay? But apart from this logo or apart from this service mark that you're seeing, they also have other things that they have registered as service marks. Can you guess? The slogan of Thai Airways. Can anyone remember what the slogan of Thai Airways is?
Chada.
Yeah, what is it?
Chada. The headdress.
Ah, okay. No, do you remember the slogan of Thai Airways?
Oh, slogan. I'm sorry. Smooth as silk.
Smooth as silk. Now, believe it or not, smooth as silk is a registered service mark. Okay, so it doesn't have to just be a symbol. It just doesn't have to be a word, a designed word, or a color. It can also be a slogan. So for Thai Airways, smooth as silk is a registered service mark. Also, another slogan from Thai Airways is I fly Thai. Again, that's a registered service mark. Okay. Then we have Starbucks. Okay. I'm not sure whether any of you have heard about this dispute between Starbucks and Starbucks. Okay, there was another entrepreneur that kind of used the Starbucks logo as a springboard to boost their own business. They called themselves Starbucks. And the logo was green. Inside, it wasn't the Little Mermaid or whatever like this, but it was a different logo, but it had some similarity. Starbucks took Starbucks to court, and obviously Starbucks won. But that just proves that the goodwill or you know, the value in IP can also be used or abused, okay, by other people and other entrepreneurs. This is, do we all know what this is? Can someone guess what this is?
It's Netflix.
Netflix, yes, correct. Good. So a lot of people who now do not have, you know, those true boxes or cable boxes or whatever, now you can look at the television on your phone, right? So basically, you just download Netflix, you download View, ECE, and things like that. When this N, red N comes up, a lot of people instantly know that it's Netflix. But also, did you know that, oh dear, okay, how do I do this? I need to play the sound that comes with it.
Can you just...
There is actually a sound that is embedded in this video. I'm trying to... If you can just bear with me for a minute. I'm not the most technological person there is, but... Okay, let me try from here. Okay, now if I do this, do you hear that? You all heard that? Okay. Let's do that again. Okay. So that, hopefully you heard it. So basically what I'm trying to say is even a sound can be registered as a trademark or a service mark. So that sound, even without the N in red, to a lot of people, instantly when they hear that sound, they will think of Netflix automatically. Now, many of you might have read in the news, or many of you might have heard that there are other sounds out there that, let's say, for example, when you start up your computer, what's that sound? Microsoft. Windows, okay. So that sound is registered as a service mark. Then there's also the sound of engines like Harley Davidson. The vroom vroom sound that it makes is also registered. Apart from sound, there's also smell, but I'm not including an example here because I'm sure that you won't be able to smell anything I have on the screen. So let's give you an example. There was this company that does shoes. They do kind of like rubber flip-flop shoes, and even before you reach the shop, like if you're walking down in a shopping mall, maybe like 1 or 2 shops before you reach that shop, you will smell a bubble gum scent. Have you smelled it before?
Oh.
Maybe if you're a girl, you might. Really?
Okay.
No, you've never. Okay. Basically, they applied for registration of that smell, and they achieved it. There was also this other manufacturer who manufactured tires, like car tires. Okay, and they put a rose scent, like flower rose, in the tire, and they asked to have it registered as a trademark, and they succeeded.
Oh,
so as long as you can,
they can use they can use common scent for their scent. Really? Is it?
It wasn't actually a common rose scent.
Oh, okay.
It was a mixed scent that even like this brand of shoes that I was talking about, it has a particular bubblegum smell that can be distinguished. Like, so if you are, there might be other shoes out there in the world that have a smell to them, I don't know, but this particular brand, the minute you smell it, you instantly know.
Okay, so
it
another
has to be
question. Yeah. Okay.
Yeah, okay.
Okay, that means all the perfume in the world, did they register their scent? You can infringe the KC the perfume scent.
You can. Yes, you can register them, like Chanel number 5.
I see.
I think Chanel
number 5. Okay.
What?
In Thailand, there is no smell.
Yeah, in Thailand there is no smell. Yeah, exactly. But Chanel number 5, I think Chanel number 5 was the first perfume to actually get registered.
Okay, that means they have to have the electronic nose to identify it, not just the people smell, because as people have different nose, they can smell different way. So this is the technology come in to identify that smell. You think?
I'm not really sure how they do it. My understanding is that they actually use humans, right? They use humans. They don't use a machine.
Yeah, they have to protect it in court, and I think it has to be very precise smelling. So
exactly. That's why it's so difficult to register, because it has to be a very, very distinguished kind of smell.
Okay, thank you.
Okay? Unfortunately, Thailand is not registering smells yet, but we are hoping in the future that actually, which is such a pity. I'm so sorry, I'm turning around because I'm talking to my colleagues here as well. So it's such a pity because in Thailand, we have so many cultural smells, if we can call it, right?
Unique smell, yeah.
And yeah, they're very unique smells. So I think once this opens up, hopefully, well, okay, my colleague is laughing here, so I think that's probably in the very far future. Okay, but anyway,
durian smell, for example, durian smell, we shouldn't let anyone to register it, right?
Maybe you have to adapt the durian smell in such a way because it can't be a typical durian,
okay,
right? Like a rose fire.
Yes. So this is deep tech, people. Electronic nose. Thank you.
Now, who knows? I mean, deep tech, you might come up in your lab a particular substance that gives a certain smell. Or can we register taste?
Not yet.
Not yet. Even taste we can't, right?
Yeah.
Okay. Now,
So for the sound, it's very hard now for the trademark office itself, even though they can register in Thailand.
yeah.
But they need some technology that to distinguish from the others.
Yeah, exactly. Anyway, okay, so for a trademark, I'm so sorry, my slide is wrong. It should actually say trademark service mark. For a trademark, your rights will commence upon registration. So here, this is different from a copyright. For trademarks and service marks, it requires registration, okay? And there are certain elements to it. First of all, that trademark or service mark has to be non-distinctive. That means if you are a lending company or a financial institution who gives out loans and you want to register the trademark or service mark, easy lending, no can do, because it tells you what your business is. That's the what do you call that? This is the humor in applying or registering or coming up with a trademark or service mark. Whatever trademark or service mark you come up with has to not describe about what you're doing. Apple does not describe computers. Starbucks does not describe coffee. Also, it has to have some element of design. It can't just purely be a word. In the old days, maybe, yes, you can probably register a word and you waive the right for other people to use it. But nowadays, it's very, very difficult to actually even register a word without any sort of design in that word. However, if it's a word, let's say it's Lati Bolala, and there is a certain element of design in it, then it's more likely that you will receive registration because of that element of design, okay? The period of protection for a trademark or service mark is 10 years and it can be renewed. So as long as you keep renewing it, or whoever's, even if you die, people keep, your successors keep renewing it, then that's fine, okay?
Can I just emphasize the difference between, the copyright and the thing you just explained? So if I have a building, and I love Van Gogh so much, I can scan his starry night picture and print it on my building without infringement because he has been dead, or he has been created this picture more than 50 years. Is it correct?
What is that building for?
Just an apartment building. Let's say apartment.
Are you going to rent out the apartment?
Yes, correct.
If you're going to rent out the apartment, then you can't put his Starry Night on the building.
That's mean if you say that the copyright is extend after 50 years of creation, we still cannot infringe it. For how long?
With copyright, there are so many copyrights out there. The Starry Night has been reproduced and reproduced and reproduced.
Okay.
Right now, it's not only Van Gogh that has, his copyright must have died some time ago. But the Starry Night picture actually has other people holding the copyright because of reproduction.
Oh, okay.
Exactly. So it's like a song. So let's say, for example, I grew up with, who did we grow up with? Let's say we grew up with, I don't know, Whitney Houston, okay? So growing up, Whitney Houston sang some songs, and now her songs are being reproduced, right?
Ah,
And so there will always be somebody owning some sort of copyright related to her song.
like someone who cover her song. After
Correct.
her copyright expire, those person will have a right to that cover. I understand.
Yes, correct.
So,
Correct.
understood. Okay,
Okay.
clear. Thank you. Yes.
Now, some other, another type of intellectual property is what we call a GI. This is not GI Joe. This is geographical indicators, okay? Now, this is what, okay, my father's place, we sell noodles, and we sell noodles called yen tafo wat kek, okay? So yen tafo is a kind of noodle with red soup, and wat kek is the,
somewhere.
is the shrine, what shrine is it? It's a, no, it's a Brahmins, เป็นวัดพราหมณ์เหรอเป็นวัดฮินดู
Silom Indian temple.
Yeah, it's an Indian temple. Okay,
Okay.
I'm sorry, I'm not sure whether it's Brahmins or Hindu, but it's a temple on Silom Road. And the only reason why I call my noodles yen tafo wat kek is because my shop is located directly behind wat kek. Now, if I were to go and sell it elsewhere and claim the use of this particular name, I can't use it because my geographical indicator is not in Wat Kek. So let's say, for example, we have Doi Tung coffee. So all of the coffee that uses Doi Tung coffee comes from Doi Tung. If it comes from somewhere else, then you can't use this GI. Okay? We have Khao Hom Mali Tung Gula Rong Hai. So this is Hom Mali rice that comes from a certain area in Thailand. Any Hom Mali rice coming from elsewhere cannot use this GI, cannot use the term Tung Gula Rong Hai because it doesn't come from Tung Gula Rong Hai, the crying field. I'm not sure why it's called the crying field, but anyway, then we have Chianti. For those of you who love alcohol like me, you would know that Chianti is an Italian wine. So Chianti is a district in Italy where its vineyards produce wines that can be called Chianti. If the vineyards are elsewhere, they cannot put the word Chianti on the bottle. Then we have Habanos. Habanos is a Cuban cigar brand, and the leaves of the cigar is from Havana only. Okay, so that's GI. Then we have trade secrets. Now, trade secrets might have a bigger impact than you think. With trade secrets, oh, I'm so sorry, I forgot to tell you that GIs do not have an expiry date, okay? So once it's registered, it's registered, and there is no expiry date because as long as the product you are producing or the service you're providing comes from that geographical area, then you can continue to use it forever and ever. If, let's say, for example, World War III comes and a bomb comes down and wipes out the entire area, making or rendering that area unfit to grow rice anymore or whatever, then maybe that GI might be revoked, okay? But normally under normal circumstances, that GI will continue.
How big the GI the area could be? Can we just register everything Thailand? No. Yes or no? How big the geographical area should be specified?
No, it has to be distinguishable. So I can't really say whether it's big or it's small, but you have to be able to pinpoint it to somewhere. Thailand is not a GI that.
Because I heard a lot of Thailand, Thai Khao Hom Mali, Muay Thai, something like that. I'm not sure.
Yeah, which is fine because Muay Thai or Thai boxing compared to Western boxing or other forms of boxing, free form boxing. Yeah, Muay Thai is not a GI. It's just a name that we call a certain sport or art.
Oh, it become a general name.
For a GI, yes. Yeah, exactly. But for GIs, it has to be, you have to be able to pinpoint it to somewhere.
Okay.
You can use the resources in that area to produce the thing. That's for the GI.
And you have to be able to use the resources in that area.
Okay, thank you.
Okay. Now, the next one is trade secrets. So with trade secrets, let me give you some examples, because just saying that it's confidential information, you might say, well, there's a lot of confidential information out there. So what are some examples? One example is the formula of Coca-Cola, that black drink that we all so much are hyped about. KFC's chicken blend, the crusting on KFC's fried chicken. It is a blend of 11 herbs and spices. Did you know that? Now, these two are formulas or recipes that to this very day are trade secrets. There's also Google search's algorithm. That is also a trade secret. It is not registered anywhere. It is not filed as a copyright. It is not registered anywhere in the system, but it's maintained as a trade secret. Then we have a customer list. For some businesses, the customer list is very unique. Let me give an example. For girls, we know a lot about jewelry stores, right? And one jewelry store is Cartier. Now, Cartier have salespeople, and their client list or customer list, their VIP customer list, is actually a trade secret. So Van Cleef's Arpels, Cartier, Frank Muller, a lot of jewelry stores will have their own VIP customer list. And all of this is maintained as a trade secret. Now, then you're asking, okay, I kind of understand what can be a trade secret, but then how do you define a trade secret, okay? So number one, that secret or that piece of information has to have commercial value. It has to be information that you can actually use it to earn money, earn some sort of commercial benefit from it. Okay, so for example, the Coca-Cola formula, if you have it, you can produce Coca-Cola and you can sell it, right? Number two, the second factor is the trade secret must only be known within a very limited number of people, only people that need to know. So I'm calling this the inner circle. For Coca-Cola, to this very day, there are only 2 people in the world who know this information on that formula. Other people might know bits and pieces. They might know things like, okay, it's got sugar, it's got whatever, but they don't know the percentage. They might not know a certain enzyme that is put in it or things like that. So this inner circle has to be very, very small. You can't say that the inner circle consists of like 10 people, okay? So that's the second factor. The third factor is access. The access to that information has to be very limited. If the information is a tangible sort of material, like if it's printed on paper, then it has to be in a safe deposit, or it has to be in a room which is securely locked in a closet that can be securely locked, and the people who own the key can only be the ones in the circle, in the inner circle. So here, in conclusion, in order to establish a trade secret, you need to make sure that number one, the information has commercial value or can create commercial value. Number two, very few people know about it, preferably 2 or 3 people. Number three, it is not possible for the general public or even people within that company to access that information easily. Okay, so that all of these 3 factors together will then constitute a trade secret. Now, for trade secrets, again, this is not something that has a certain protection period on it. As long as you keep it a trade secret, it's always protected as a trade secret. Okay. Now we have, okay. Now we go on probably to the most crucial part that will be for your benefit, which is patents and industrial design. I have my colleague here, Kun Maturot, who will be touching on the topic because all of her life she's been doing patents and industrial design. Okay, so let me introduce you to Kun Maturot.
Okay.
So would you like to? Okay. You want to stand it? Okay, we're talking about intellectual property here, and next up we have patents and industrial design.
สวัสดีค่ะ Okay. สวัสดีค่ะ Thank you for your kind introduction. คุณสุธีรัตน์ Yeah. And Maturat Yashosukit. To thank you for having me here. That to give some knowledge that help for the engineer. Okay. First, we start with the patent and business. Why the patent have to have is important for the business? There are the patents. Okay, the patents that will be give the rights, the exclusive rights, and it is sold as exclusive rights for a patent owner. What is who is the patent owner? The patent owner is the one who creates things. Okay, that the creation will be talked about it later. Okay, the first thing is that the patent itself have to be the law, the patent law. That they give the rights, these rights, in return for the effort of the inventor or designer in a certain time, that the patent owner can exercise its rights in any way that he wants. For example, to produce, to use, to license, or to import in Thailand. Okay, that certain time that I'm talking about is that 20 years or 10 years. It's certain time because in 20 years or 10 years that you have the exclusive rights is some kind of like a monopoly. Because if you produce or if you license your patent to a company that you have 20 years last on, but after the 20 years or 10 years, your patent or your invention will have to be into the public domain. What does it mean in public domain? It means that anyone can use your patent. Anyone can develop your patent. Okay. The second thing is that since you have the rights since you have the exclusive right, you have an ability to compete with your competitor, because your innovation, your technology, that you can like moving forward of your business to in another level for your business. So you can compete, for example, like Apple, they have like not an Apple, like touch screen technology. Okay, if a company, a tech company that creates this technology, but now you see nowadays that most of the tech company that they use this technology to their device. So it means that the first one that who can create that the technology or innovation will compete with others for their technology. Okay. After the competition, yes, of course, you will get the remuneration from that right. Okay. The important thing for the patent itself is that the territory. Patent itself, once you get the protection from the law, where you obtain a patent, you will get the protection only in that country, not the worldwide. I will talk about later that there is the system, the international system for the patent, but I will touch it a little bit because there is need a lot of information. Okay, the next slide is that I want you to know that what is the patent. According to the law, the patent itself means a document that issued to grant a protection for an invention and a design. Actually, the one who can claim that he has a right, he has an exclusive right, is that you need to have this document. Okay, on the top one is that the document that the patent, the Thai Patent Office is issued is around it, is something like this. The below one is the patent that issued by the United States of America, or we call it USPTO, the United States of the Patent Office, the Patent and Trademark Office. And the right one is the patent issued by the European Patent Office. So it is necessary that a patent, if you want to claim a patent, you need to have this document. Okay, what are these documents consisting? This document consists of the details, your rights, any information that the examiner can understand, or anyone can understand your invention or your design. Okay, this is only the patent, but the patent is more than the document. But anyway, the document is anyway substantially for the patent itself to claim the right. Okay, I will talk about the invention. What is the invention? The invention here, it means that means any innovation or invention which creates a new product or process, or any improvement of a known product or process. And the product itself means any method, process, or procedure of producing, maintaining, or improving the quality of a product, including the application of such process. Okay, as you can see, who will create a new product or process? To imply to this the invention, the animal can create the product or process? No. it is need the human, or we call it human intervention, because the human for now that who can think, who can adapt, who can figure it out how it works. And but it's different from the discovery. The discovery itself that okay, for there is something that is different, and the similarity with the invention and the discovery. But as I said, the invention needs the human intervention for create things, and to think, to use the knowledge, to use the existing matter, or to use the whatever effort to put it into the product or process in order to have a new one. Wow, the discovery itself, yes, you have to use your thing, you have to use your knowledge, you have to use your adaptation, you have to use everything to find out what is that for, how it survives, how it works. But the discovery is just only for the existing ones, for the existing matter of existing objects, like the tree, DNA, protein, virus. That's all in the nature. While the invention itself, it's like the discovery is a sub detail in the invention, because in the invention you can use the discovery that you find out to gather itself and for you to consider and to review and to testing whatever. But the invention needs the technical features. These technical features have to come out from your knowledge, or from your methods, or from your invention, in order to have a new product or process or improvement. For example, as I said earlier, that DNA is a discovery, right? That the scientists have to find out what is the DNA, what are they made from, and what is effect to your health, and where are they, for example, or protein. But how we invent from the DNA, you cannot claim that you invented DNA, right? Because it's already existing in our daily life, but or in ourselves. But if I want to to increase the number, or we call the DNA proliferation, the process, the DNA itself, you cannot claim, right? Because it's your discovery. But the proliferation process of the DNA, you can claim that the process, how you increase the number of the DNA, or of the protein, or of the virus. Yes, this is the invention, because it needs the human to intervene the existing things. Okay. And so so just to remember that the invention concerned with the human intervention, but the level of the intervention by the human is another thing that we'll talk about it later. Okay, but anyway, you have to figure it out. You have to try. You have to test. You have to do whatever to become a new or the improvement. Okay. What is the design? Design is the composition of lines or colors, which gives a special appearance to a product and can serve as a pattern for a product of the industry or handicraft. Let's speak to say that it's just the outer of a product. Okay, I will put it in this way. The invention in the previous slide, is internal of the product. Is the inside the product. Is the method, or even though it's a product itself. It's a product itself, like the new chemical substance or the new pharmaceutical composition. This is we call the product. And the process itself, how you produce the pharmaceutical substance that to cure the cancer. This is the process. Okay. Wow. The design itself is like okay, let's speak easy to say that it's like a packaging, or it's like the tablet. It's like the pills. That how it's designed. Like you may have like a special design for pills, or something like the phone, the camera, the whatever. Is the outer, is the appearance, how you see things. That is the design. Okay. And the types of the patent. Actually, this is these three types is the three types that the law is protect for your exclusive right, or to give the exclusive rights to you. The first one is invention patent. The invention patent is the invention, like I said earlier. Okay, there is the requirements that there is the highest requirements among these three. I will talk it about later. And the petty patent or utility model. Some countries call it like a utility model. Okay, but in Thailand they call it a petty patent. Petty patent is like is a petty. It means that it's smaller than the invention patent. Okay, and the design patent. Okay. Okay. I will talk about it, the unpatentable matters for mention of the invention patent and petty patent. Since the invention, the petty patent and the invention patent is concerned about the invention itself. So these matters are applied to these patents. First is naturally occurring microorganisms and their components, animals, plants, and extracts from the animals or plants. For example, fungi, virus, viroid, vector, mycoplasma, and as I said, DNA, gene, and protein. Or even though the plant extracts, the extract from the plant is the natural products. You cannot claim, but if you have the process that you want the plants to give more the extract, that is the process. It can be patentable. Okay. The second one is scientific or mathematical rules or theories. This one is some kind of, you can call it like a discovery. Discovery itself, because these rules or theories already exist. You can just to find out or to think about it harder, that what are they? So no one can claim because it's already there. it doesn't matter. It doesn't mean that if no one can find out the scientific rules, these specific scientific rules, they can claim their discovery. It is not, because it's there, but just nobody find out it yet. Okay. 3, computer program. Like Kun Suchirat said, that the computer program is some kind of the copyright things that you can claim for the copyright, but not for the patent, because the copyright is because the source code of the copyright, the source code of the computer program is considered as a copyright thing, copyright matter, not the patent. Okay, it's like it's a kind of the novel, it's a kind of the written. So it's not, it cannot, it is non-patentable. Okay, and but if you use the computer program with the device or with the machine, that device or machine or that process can be patented. Okay, it's different matter, because the computer program itself is not, is considered as a copyright, because it's some kind of like it's considered as a novel, like this written thing. But if it works together with the device or with the computer or with the system, it's another matter. You can claim that thing, that's the new thing. Okay. Or the fourth one is the method of the diagnostic treatment or cure of the human. The method of the treatment, this is quite, I have an experience on these unpatentable matters, because the pharmaceutical composition that the patent owner would like to have in Thailand, they most likely that to want to have the method of the treatment. But in Thailand, they cannot. But you can change a little bit on the wording itself in your patent, because the law views that this method is like a you require the expertise of the physician. So it's not the anyone can do, but it's just only that physician. So you cannot claim the patent. Okay.
How about the plants? The method to diagnose or cure the plants?
The method to
cure the plant disease. Plants. ต้นไม้อะค่ะ
the plants.
Can I patent?
It's not the yes. I think it's patentable, but because it's like it's because you intervene to you interrupt or you figure it out how you kill the plants, right? It's not the method, because this is the only human and animal.
Oh.
Okay.
So it can be a
But
detailed patent for plants. Yes.
Right.
Very good.
Right. But you may have like a process that you process that you kill the plant or the treat the plant.
I see.
Okay.
Thank you.
The fifth one, the last one is the illegal invention, or like an illegal drug, or like illegal drug, or the bomb that you mix the substance, the chemical substance, and for you create a bomb, for example. Okay. This is the 5 unpatentable methods. So when you create things, you need to realize of these restrictions. For the design patent, this is just simplest that because design is not children that are contrary to the public order or morality. Yes, of course, for sure. You cannot create, you cannot design a gun, right? A gun that can kill the people. Okay, and these things that is against the public morality. Okay, this is how I compare that for your understanding that how to separate or how to understand on the what type of the invention and the design. The invention, yes, as I said earlier, that is inside the thing, inside system, the inside the car, inside the machine, how it works, how it affects, or what is the outcome. But for the design is just the outer of the product, or for this case, it's just a car, how it looks. It may or may not affect to the outcome of the product or the outcome of the internal system of the car. It may or may not, or maybe just only the pressure thing, or how it looks, or it's beautiful, or it's cannot, it's unacceptable for whatever. Okay, so this is the thing, and it's the difference. And okay, for the invention, this invention is also applied to the petty patent as well, because petty patent is smaller than the invention patent, but it's the same thing, that it refers to the internal substance of a subject. Okay, this is the requirement under the law that but this requirement is the acceptance in worldwide, internationally. Every country will have these three requirements. If your patent, if your invention doesn't meet these requirements, you will not get a patent. So apart from the human intervention, the level of the human intervention, as I said earlier, it must meet these three requirements as well. It depends on the field of your science or the art that your invention is involved with. Okay, the first one is a novelty. Okay, the first one is novelty. Novelty, what does the novelty mean? Novelty of an invention means that it's new if it does not form part of the state of the art. It's new. New is mean that it's new. It cannot found in anywhere in the world. How do we know that it's new around the world? There is a database, the patent database among the patent office worldwide. I will talk about it later, okay? But the level that is new, that to consider as a new for the patentability is that you have to know all around the world. Even though that you registered only in Thailand, but the examiner has to find out that whether this is new in other countries as well or not. Okay. If it is, okay, you go to the next requirement. Okay. For now, that's new. Just you remember that, like this state of the art. State of the art is the what does it mean in the state of the art? That in the legal view, It means that the invention which was widely known or used by the others before the application, before you file the application. And second, that describe in describe or print publication, display or whatever before the date of the application. The third one is that it was granted in Thailand itself or the foreign country before the application. Why I have to emphasize on the before the date of the application? Okay. The fourth one is that the apply in the foreign country more than 18 months. And the fifth one is that to publish in Thailand or other countries before the application, because in the legal view, it open that they have the opinion that the date of before the date of the before the date application is that your invention will not, it's like some kind of like the restriction that your invention will not similar or copy from the others, because you don't know what the others invention. You don't know what they are doing, even though that they are come up with the same result, but you and I produce in the different way. You don't know that what I'm doing, and I don't know what you are doing. But even though they are the same outcome, it doesn't mean that I copy you or you copy you copy me. Okay, so if your invention doesn't found in anywhere around the world before your application, before you file the application, it means that your invention is under the law. Okay. So before the date of application, you see that every state of the art, every clause, it emphasizes on the before the date of the application. I want you to put this in your mind because this is quite important for the patent itself. Okay. And next thing is that the exception of the state of the art, even though that the law indicates this the exception, like within 12 months, that if you disclose your invention within 12 months by yourself, by the inventor itself, you still can claim, you still can file, or you still can have the patent. But in the practice, it's not just easy as it is. Okay, so I rather to suggest that you do not think about this exception. You just think about that before the date of the application. Okay, so you shouldn't do anything with your application, with your invention before you file the application. Okay, you may confuse a little bit. Okay, the protection under the patent itself in anywhere around the world, and this is the internationally acceptance, is that you need to file an application with the authority. So the requirements that I'm talking about is the requirements that the examiner have to examine your invention, your application. It cannot come out your rights, your monopoly rights or your exclusive right just not come out as when once you finish your invention. It's not like that for the patent. You need to apply for a protection with the authority. Okay, so that's why the state of the art all items they state that you need to your invention will consider as a new if your invention doesn't found in anywhere in any document before the date of the application. So before the date of this application, you shouldn't do anything, even though the published by yourself. I suggest that to apply first and then to publish it later. Okay, this is the weak point for the. But I understand that in terms of the, in view of the inventor or in view of the patent owner, that okay, I succeed to inventing. This is a new thing. This is the very extraordinary new thing to the world. So want to come out with the idea and to let the whole know that what are the things that you come up. But hold on, because there is hold on, because there is somewhere that or someone that can ready to copy you and to like a counterfeit of your product or your process. Okay, so I suggest that to file an application first. It will be safer.
Can you tell us what is the name in Thai of state of arts?
งานที่ปรากฏอยู่แล้ว
งานที่ปรากฏอยู่แล้ว Okay.
This is the terms from the law from
Okay.
the Patent Act itself.
Okay, thank you.
Okay. For the next slide is the second requirement of the invention patent is the inventive step. Or I will say it in Thai, right? Okay, this is the required การประดิษฐ์ขั้นสูงนะคะ inventive step. How you know, how the examiner know that whether is that the having the inventive step or not? If you compare to the person ordinary skills in the art, it means that the scientists in the same art or the relevant, just only the ordinary skill, not the expert. Okay. So if the person have a ordinary skill in the same art, don't know that your invention you can invent or you can get this product. Yes, this is you have the inventive step. It doesn't compare to the expert who are in this field of science. We are not have that high qualification. It's just the ordinary skill that such person can imagine or can think about it or not. That the solution that you made or the process that you invented can come out like that. Okay. The last requirement is that industrial applicability. The industrial applicability is that for you to capable of industrial application, if it can be made or used in any kind of industry, including handicrafts, agriculture, and commerce. So you can earn the money from that, the result of the industrial applicability. Because since if you have like a product, produce something, you are not, if you are not produce something with your effort, with your time, with your testing, but it cannot use, it cannot be used, it cannot be produced. So what is the patent for? Because the law gives you a monopoly or the exclusive rights for 20 years or 10 years. But in return, that you have to give them, that you have to give the public for the knowledge, for the technology, for the innovation. For the others to study, to improve. Okay. And the next slide is.
Can I ask for the clarification of the industry application? For example, if you invent something like something that very incredible. For example, you can move yourself very fast into some dimension, say something incredible. So this thing industry cannot make money for it at the moment, or even though at this 100 years that industry cannot make money. So you cannot apply this into the patent. Is it correct?
I think the way that you can move things to the other dimension that is not like it's not applicable. It's not,
okay.
It's not have the industrial applicability, but the tools, the way, the instruments that you can make things to the others is another thing.
Yeah. Okay.
Okay. You can use the thing, the tools that you made that for the others.
Okay.
Okay.
I see. So maybe my example is not very good. Say your invention is not something applicable for industry to make money in these 50 years. You cannot make a patent out of it. Is it?
Right.
Okay.
Okay, I will give you an example because I just have an application that rare application that found in the America, in the United States, in the Japan, in the China, that they refuse, the examiner refuse or object that rejects the application because it doesn't have the industrial applicability, because it's concerned about the chemical ขอโทษนะคะคือพูดภาษาไทยนี้การกำเนิดพลังงานจน
Kinetics
คือ
how kinetics energy originate something like that พลังงานจน
something like that because most every country that they say that this is just a theory.
Oh, I see.
The
okay.
rule, not the cannot make the
has no
produce.
commercial value. Has no commercial value. Okay.
Right. But in some countries, they said, oh, okay, in Japan itself, they have objection, but they have the objection, and but I can say that it's quite fast understanding because for the Japanese examiner, because when we amend the application or we just amend the wording in our rights in the patent itself is and for not long the patent is granted. But for the China and for the United States itself, it's different thing. We have to make the effort on the application because it says like that. it's quite rare that to have the objection on these requirements.
Okay.
Most of the requirements that we face to object and to unpatentable is that for the first two, that the novelty and the inventive state. Okay.
Thank you. Okay.
Okay. The requirements of the petty patent, there is just only the two. The basic is the same, but it cuts out the inventive step. As I said earlier, that the novelty, because this is the petty patent is quite simple. They want to motivate the inventor to create things, that the simplest, not the hard one, because there is so many inventors that can create things that a little bit here, a little bit there, but not has the inventive step enough. Okay. For the design patent, this is just only the two things, but for the design, it's the same. The new and the natural applicability. And as you said, there is just only two. The number of the years to protect is less than the invention patent. Like we call like the invention patent is a father, and the design patent is a mother, and the patent is the child. Okay. Because the invention patent is the highest one that the law can give you, that can give you a monopoly right for the 20 years. Okay, the newest of a design, like I said, like it's likewise the invention patent, like the exception for the invention for the law also said that your design shouldn't disclose, shouldn't use, shouldn't publish before to file the application. Okay, so in detail you can read it after that, but I want to emphasize that for the patent itself, you want to protect, I would suggest that you shouldn't do in public, in commerce, before you file the application. Okay, and because I have to go early. Okay, this is the patent rights that the acceptable under the law, that the product patent and the process patent. The product and the process is, like I said earlier, that to tell you that the product itself, like you have the transmission of the hybrid car, that this is the product. Oh, sorry, the product itself is oh, I'm sorry. The product itself is like you create a vacuum, a sweeper, or a bicycle. Okay, a bicycle or a bicycle. This is the product. The product that you, or the motorcycle, this is the motorcycle is the product, because it has to consist of the motor, the tube, the whatever. This is the new one, a new product. For the process itself, like how you make your bicycle or how you make your motorcycle move. This is the process patent. Okay, and okay, as you can see, the product patent, your patent can be produced, used, sell, have in position for sale, or offer to sell, or import product. Only for your patent, only. If someone produce something that is produce the motorcycle as same as yours, with different process. So he also can claim his motorcycle and his process. So it doesn't mean that he copy you, but both of you have to have a right only on your invention. It's not like oh, nobody can produce or cannot produce the motorcycle in Thailand. No. You can prevent only from anyone who wants to counterfeit your patent product or process. As long as they use the same, as long as they use your patent to figure it out, to manufacture their counterfeit. Okay. This is the exception of the patent rights, like a study, research, experiment, that okay, and the production. I will leave it to you that to consider like the compound of a drug or the drug registration. The fourth one is important that because for production of the pharmaceutical substance, that every country that requires the registration with the FDA in each country. So the pharmaceutical companies that they know that you produce like the medicine for the allergy in the children, that they want to sell, they want to produce, they can give the information in your application to ask for the FDA approval, but they can only produce after 20 years of your patent life. Okay, it doesn't mean that they will, when they apply with the FDA, they will get right away, but they need the information. And as I said earlier, that once you got your patent is expired, it will be in the public domain, so anyone can access to the information of your patent. So that's why the pharmaceutical company can have the information of your patent. Okay. This is the vessel come in the country and the aircraft. Okay. And this is the basic thing, because the one that to have the authorization from the patentee, from the inventor, or from the patent owner, they can use your patent because they got your authorization. For the design patent, just only it's quite the same as the invention patent or the petty patent, that you can sell, you can have, you can import. And for the exception is that the use of the design will exclude from the study and the research. Okay, this is the term of protection under the law, that the invention patent itself, like I said, this is the father, that is 20 years, that you have the right, have the right for your use, for your produce, for your license in 20 years. For the petty patent is actually the term of protection is 6 years first, and then you can renew in twice. Okay, but maximum is that 10 years. And for the design patent is 10 years. Once you meet the requirements of the law, like I said earlier, they will give you 20 years, 10 years, and 10 years. However, from the term of protection, the starting date is that from an application filed this is maybe this is under the law says that, but in some countries that they starting date, it means that starting date that you can have your sole exclusive rights in your patent is that from the registration date, which is like the extent is like considered as the extent period of your patent, but in the Thailand it's not. Okay, and however, why I have to emphasize on this, because as I said, there is the requirement. There is the two important requirements is the novelty and inventive step. They have to have the examiner have to consider and have to examine, have to read all the publications, have to find out the database, have to find out from the other patent office in other countries or in the organization that they cannot come out. They don't find your similar patent. So it takes time. Takes time is mean that maybe 10 years from the starting date, from the application date. Some technology may have only 4 years to get a patent from the application date. Okay, some may have like a pharmaceutical composition that I have a case is that nearly 20 years. But it doesn't mean that you are not during the time from the application date until the patent is granted, you cannot use it. You still can use it, but there is some restriction. Okay. Oh. The obtainability of the patent, right? I will first, you have to registration. You have to register your invention, your design. If not, you not have the exclusive right. If not, anyone can copy you. Anyone can buy your product and copy it right away. Okay. This is how important, because your rights, your patent rights come from your registration, not just come out easily once you get your invention done. No, you have to go to Department of Intellectual Property. This is the authority that you give you a patent, that you examine your application, your invention. And when you should go to the DIP is that when you finish your invention, when you have a successful invention or design, when you come out with the design that you want. And why? Why? Because you will get, once you register, you will get the rights. You can compete and you will get the remuneration from your patent. Like you can license. There are many tech companies that they license back and forth to among themselves. Like a LCD, the television for the LCD, the LCD monitor. I'm not sure that who invented it first, but the later one, the later tech company that have to get the license from the first one, or maybe the second company, tech company is can create the remote control, for example. Okay, they will. The first one cannot, so they will license back and forth to each other. This means that they will have the financial consideration among themselves. So you still can have your own rights to use it, but it depends on the terms of the agreement between both of you. Okay. The current, like I said earlier, the current patent system. The patent system, there are three systems. The national patent. The national patent is that the patent that is filed in each country. It means that in Thailand, you file a patent in Thailand, you file a patent in China, in Japan, in the United States. That is the in terms of like a territory, like in each jurisdiction. Okay, how among ASEAN itself, they don't have the regional patent. Okay, the regional patent is that the patent that is issued from the regional office, like European. In the Europe Union, they have the European Patent Office. It means because as you know, that in the Europe, they have the member states. I think maybe 30 something. So they have the center we call the regional patent office. This European Patent Office, which is the regional patent office, will be once you get the patent from the regional, from the EPO, this will you can use it in everywhere among the European Union. Okay, and the last one is the international application. The international application is not a patent. It's not a patent itself. It's just only an application. Because why? Because this application is organized by the World Intellectual Property Office or WIPO. But for the patent itself, we have the Patent Cooperation Treaty, which is the WIPO will not grant that a patent to the patent owner. They just only to search for the novelty, for the inventive step, and for the industrial applicability. The authority to give you the right to use is the national patent and the regional patent. But this one, the international application, is like one of the mechanism that to give you more consideration on your filing of a patent, because filing in abroad, in Japan, in US, is quite expensive, and you may not know once you get your invention done whether your invention is interested to anyone or not. It's like marketing. You do not know that whether is there anyone who is interested to your invention or not. So this PCT system is like prolong your decision to go through the national or regional. Okay. This employment relating to patent is just like if you are the business owner, you have to you should, an inventor itself or designer itself, you should put this rights in the patent to the agreement. And there is a right for the employer to receive the benefit from the invention or the design, as long as your business owner, or as long as you can make a profit from the invention. Okay. Okay. This is the how I like to suggest that how you should begin with your patent. Okay, the first thing is that you have to search. I put the worldwideweb.ipthailand.co.th. This is the website of the Department of Intellectual Property of Thailand. They have a database, and they can link to the USPTO or the EPO or the Korean IPO or the Chinese IPO or the Japanese patent office. That you should, if you want to invent something, I suggest that to search for it first, because it might have the similar things as yours. So if it is, so you review it, that whether is it the same or similar as yours or not, and whether you can develop or inventing something different or not. Okay, and then if you develop and inventing something from the database or from the prior art in the database itself, that you should test and or give the prototype, or you like a testing on your invention, but to test that, to prove that your invention has solved the problem that you find out, or have the successful outcome that you hope for, or you can, if like the mechanical or whatever, you can make a prototype. That's how you to developing things. So searching, reviewing, developing, and testing. Okay, and then preparing what? Preparing the application, the information of your invention. To prepare it, that there is the more details on the preparation. So, and then you go to the DIP for registration. As you said, I didn't put the publishing on your invention, because I would rather to suggest that you go through the process first, and then once you found it, you found your application, you found your invention, that you can go the publish by yourself or whatever, or sell it or whatever. But yeah, okay, and how? Okay, I will give you some examples on the invention that registered in the DIT. Is that the system, because this is they want to reduce the number of elevator shafts to increase the building space. So this invention is create a new system that to having 4 or more cabs to operate more independently from each other in each single elevator shaft. Okay, and the other. This is also another example. Like this is the background and solution is not, when you find the equation, it's not just like that. This is just, I summarize it for you to easier understand that what it's for, because as you will see, okay, this is the third one, the insulator. They also have a problem. First, why you want to invent something? Okay, because this is like an insulator, because there is a noise, abnormal noise between the first hole and the second hole. So they want to reduce the noise. This is a solution. You should have the objective of yourself, of your invention, that why you have to invent your invention. And then your invention has to solve that problem. Okay. Every single application have to have these two information in the application. And this one is the treatment, the treating surface of move. Okay. As you see, in each example, that there will have a drawing that for you to easy understanding the invention. Not for you, but for the examiner. For the examiner to understand what is that for. But some technical field, like for the chemical substance, for the pharmaceutical itself, they cannot put it in the drawing, but they can put it in like a graph, or like in the screen, in a slide. They put it in like the ratio or whatever, the theory in that. Some pharmaceutical composition, they put like the test result with the subject and how many subjects that they used to, that they test with, and yeah, they put it in. It doesn't matter that whether your application has the drawings or not, but the important thing is that your application should make the examiner understand your invention. That's all. This is the sample of the petty patent. As you said, as you know, as you see, that this is a quite simple form with the spoon. This is the existing one, right? The foam box. But whether is there any box, the foam box that has spoon on it? This is the not having the inventive step at all. They have only the novelty. They have only the novelty is new. Okay. This is the fish tank table. It's just like the two things combined together. No one can create things. No one never have this thing before. Okay. Okay. This application is registered as a petty patent. But someone may to argue that this should be have for the patent, invention patent. But it depends how it works, whether is there any inventive step or not, or maybe just the combine two things together and put the tube, the hole, whatever. Okay, it depends on the application. This is the dentistry. I think it is for the few. Okay, this can adapt from the real dentistry chair, but it can movable. It's movable for maybe the up country or the this is the design. The design, the example that I gave you is that the mechanical arm that you have to there is the okay the design itself. It can protect in 3 dimensions or 2 dimensions. This is the 3 dimension because you can have the different angle of one mechanical arm. This is the perspective view, the overall. This is on the top view. This is on the left side and right side. Okay, you have to, when you file the application, you have to put it clearly to have to give the examiner understand your design. Okay. And this is a transporting machine. They 2 transporting machines. This is the first one. This is the first one. No need for no need for the design itself, no need for the explain how it works, just to show the design. And for the second one is that this one. This one is like can, apart from the transport, they can select the goods as well. So, but actually, the examiner may ask that what is that for, but we just have the brief explanation on that. But the important thing is the design itself. This is the mobile phone. Okay. The mobile phone. This is the first design. You may figure it out that what is the for, what is the name of the company, and the second one is this is another design. This is the camera that you pop up when you, I'm not sure, but when you press the button. But I know that this design is no longer used in Thailand with the camera pop-up, because there is something with the dust. There is something that with the dust, so the company does like cancel this design. It means that the design or even the invention itself, even though that you did produce, it cannot be sure, or it cannot 100% ascertain that you will use it, you will license it, or you produce it. Okay, because for the later day, you may have some obstacle from your design or from your invention that you didn't expect at the time that you invented it. Okay. This is the mouse, or this is the two design. This is the first one. I think some may use it already. This is and this is the second one. Okay. And this is the different design. And door locks and keys. Actually, these door locks and keys, they are different designs altogether. It's a 3 application. Actually, for one design itself, you can have more applications. For one product, you can have the more design in the product. Apart, in addition to that, you can get the invention patent. You can also get a design in one product. And that design, it can be any numbers as long as it fits in the requirements. Okay. For example, like this design, they also have like this one for an application as well. And another application is like this. You can like break it too far in each application. And for the third one, they will be like this. And this is the key for use for this design. Okay. This is the two washing machines. The design is the outer appearance different, right? So you can see this is the first one. You may notice in the market. And this is the second one. They are different. Even though they are different machines, they are different design, even though inside they have the same invention. You can get the design for your design. This is the sweeper or the robot, the robot that you're familiar with. This is the one design. This is the 3-dimensional You can file it with your photograph. This is the first one. You can have the examiner to clearly see what are there and what is your design. And this one is just a charter of the super. This is the two-dimensional. This one is quite new for the design itself, or maybe it's not new, but it's quite popular nowadays because it's, as you can see, is like the screen page of a mobile phone. Yeah, you still can get the design. And another thing is that I didn't put in the example is that the pattern of the cloth or the pattern for the label. Some they of like the back of the snacks that they have they design the back, the snack bags into a bag when you buy a snack. Yeah, and they have it. They found the application that can be patentable. This is a doll that actually they found it in the black and white, but I show you for the color so that you will be more understanding. This is a three-dimensional because I understand that this doll cannot draw in the two-dimensional, so they put it in this, so the examiner can easily understand that what and the size and the color itself is not the things that the examiner has to grant your registration. It's just only the design, while overall, even though that you put it in a smaller size of these dolls, you are still the owner. Bracelet. This is the design of the bracelet. And the back, this is the nose that the back is also the design in the back. Okay. The last thing is that there is a dispute on the elite ball or the fire extinction ball between the Thai company and the Alibaba website. The patent information is that the Thai company is that have owns the Thai patent and have the US patent, and they also filed it with the WIPO. So the first defendant is that the Alibaba advertising, and the second is that the second defendant is that the Trademark. So the Thai plaintiffs that say that the Alibaba infringed their patent product because the Alibaba advertise and sell the counterfeit product of their five distinguishable on Alibaba website, including for the AliExpress to delivery. So, and the damage that they claim is 1,000 million baht. This the plaintiff said that they found this infringement since 2012, and they said that they bought this AFO product Bible for that to test with the IP and with some institution in Thailand that they all confirm that it is the counterfeit product. And I will show you the timeline. This patent itself, they filed on the 8th of May 98, and the expiry date is the 7th of May 2018, and filing a court case in 2017. As I said, they found the counterfeit product in 2012. They take 5 years to have a case, to file a case with the IP court. So this is just only the IP court. This is like the special court or the court of first instance. And the IP court will have the judgment on the 24th of this month. So we'll see that whether the 1,000 million baht will reward to the Thai company or not. And I expect that even though that the decision is in favor in either side, that any side will bring this court to the Supreme Court, because the damage is quite high, and it depends on the evidence that the Thai plaintiff proved to the court. And the next slide is that the case between the Google and Sonos. This is a quite recent case, because as you know that Google has a Nest, Google Nest and Google Home, and Sonos also has a speaker as well. In the patent itself, for the Google, from the news, they said that the patent of this dispute is that for the smart speaker and sound system, there are the 5 patents for this product. And Google said that the news said that Google infringed on several of its patents of the Sonos patent, including the technology used to set up a new device, use a control device to instruct speakers, create a speaking grouping, and synchronize audio across multiple connected speakers. These are the patents of the Sonos that Google infringed. Okay, and finally, after the long battle, on January 7th, the US ITC that has the authority on the importation to the US ruled that Google had infringed on Sonos 5 patents. So the Google must remove those functions from its smartphone, from its smart speakers, and accompanying the software of face and import ban from the device. And the product effect to this decision, as you can see, that not just only the Google product itself, they are effect to the others that use the Google ecosystem as well, like JBL smart speaker, Lenovo smart clocks. Yes. As a result from the US ITC decision, Google doesn't have to stop the infringing products. Instead, it's making change to the functionality with the firmware updates and removing the offending product from its Google Home mobile application. So this is the Google is doing. the Google is doing that remove the ability to control the volume of the multiple speakers with a single command. So it means that you have to control it individually from now on. And the ability to adjust speaker group volume in the Google mobile app using your phone's physical volume controls, and the ability to add new devices to the Google Home application. Okay, that one it will be, oh, not yet. So from the news, it says that Google, yes, of course, doesn't disagree. No, Google disagree with the decision, but eventually they will have to comply for the time being. So you will not see these Google products in the US, but for in anywhere that yes, you can see it. But I think for the removing the features from the Google mobile application itself, I think it's effective. It affects all over the world. So because they will like to avoid any more dispute. And since the US ITC is just only the importation ban for the Google and the Sonos itself, they are still have the dispute. Sonos also suing the Google for the damage into state. I think one is the San Francisco, and the other state, I'm not so sure, maybe Los Angeles or yes, there are 2 cases pending. So we'll see that how many that Google have to pay the Sonos for this infringement. Okay. The last one that I would like to, this is the recently news for the BlackBerry smartphone on the January 31st, that the BlackBerry has sold their application as their patent access to the Catapult IP innovation. This company, Catapult IP innovation, is like a special company to receive the patent assets from the BlackBerry. Okay, in terms of the legal, it's different person between the BlackBerry and the Catapult, even though that they have the same shareholder. Okay, that's good to say. And they sell all the patents regarding the non-core patent assets which related to their smartphone, to their BlackBerry smartphone, to the Catapult, the BlackBerry Messenger, and wireless connection to Catapult for $600 million. So it's a non-core patent asset. What does it mean? It means that from now on, the BlackBerry will cease the business of the smartphones, but to go into their current core business is that the security solution for the enterprise and for the operating system. However, the BlackBerry is still have to pay the Catapult for their non-core patent assets, because they still use the application for their business. It's like a one pocket to another, money one pocket to another. So I want you to know that the patent itself can sell, is valuable, and is commercialized. So it will return to my first slide, is that if you have the technology, the new innovation, so you can get your profit from them. Thank you.
Okay, now we're all we're all laughing here because I think we've kind of eaten onto the time more than we thought we would. So without further ado, I have my last colleague and actually my current boss with me. He is Kun Chinapat Visutipat, and he is our tax expert. And the reason why I am touching on tax is because your course is deep tech entrepreneurial. So today, Kun Chinapat will be talking to you about the tax related to deep tech technology. ขอบคุณค่ะ
Okay, thank you, Kun Christy. Not sure whether you can see my slide. Yes.
we do.
Yes, yes, we can.
Okay. Thanks, Professor Nongrat and Sarada and our students here. I will spend time around, I think, 15 or 20 minutes as the last man for this morning, but not last man standing, just sitting now. Okay, not much slide. And then I will bring all of you to join with the another world of the legal and tax. When you start with the legal protection, when you start with the case study from the IP court, and then how to generate income from your IP, how to control and manage your tax when you generate income with a high revenue. And then I will just touch point from the tax ecosystem in Thailand, and I will advise and suggest you for the case study, and then we can learn from the case study. Okay, right. Okay, this is the ecosystem of the company. When you create your IP, your patent, your trademark, your software, you can bring it in the capital of the company. And why we use the business model as a company? Because when you compare with your personal tax and corporate tax, you can imagine that the progressive tax rate for the personal income tax is higher. We start from 5, 10, 15, 12, 25, 30, and the maximum rate is 35% for the personal income tax. Different from the corporate tax rate, 20 for corporate tax rate. But you know, in Thailand, not only 20% for corporate tax rate. After the tax 20%, you will have the dividend, and Thailand charge the dividend tax at 10%. You can see from the slide that I bring for you. You can see if your company generate income from license, IP license, or IP fee, and you have the expense, the net profit, for example, 100. Corporate tax is 20%, and then dividend 80. When you pay the dividend from the company, you are subject to dividend tax at 10%. It means that you will pay another tax. That's why the effective tax rate will be 28. Compared with 35. This is a business model that we can compare that. If you are the owner of the IP, if you create the software or IP asset, you may select to adopt and generate income as a corporate model, not personal model, because the personal model will be hit the higher tax rate. Okay, go back to the slide. Okay. From this slide, you can bring the IP asset as the asset of the company. It means that you can use the capital not only by cash but by asset, for example, by the intellectual property or IP asset, intangible asset. But don't forget, when you transfer your IP asset that you own by individual, you are subject to tax law. You are subject to tax law. You know, in Thailand, you can pay the capital of the company by 3 ways, optional ways. The typical way is a cash. But if you prefer not to adopt the cash transaction, you can use the labor, like a startup in general. Or you can adopt the asset swap with share to become a corporate capital and register with the Ministry of Commerce. This is by law. This is allowable. For example, you can use your software to be the asset of the company, and you are required to evaluate. The evaluation of the IP asset is required by company law and by tax law. And you know, the valuation in general, you can use the future approach, future revenue as a revenue approach, or you can use the past performance as the cost approach, or you can use the market approach by way of a comparable benchmark. And then we will discuss on the valuation later. Okay, this is the slide that let you know that it is flexible for Thai company, and you can use the IP asset as the capital of the company without cash. Okay, and this slide will tell you about the Thai tax ecosystem. When we discuss on the ecosystem of Thailand tax, the first tax is a corporate tax. Corporate tax, and the second one is the VAT. In other countries, you may know that, for example, Singapore, Australia, they adopt the GST, goods and service tax, similar to VAT in Thailand. And then VAT will be imposed or charged this tax when you transfer the asset to the company, when you sell this the product, when you provide the service. And then we start with the corporate tax, we start with the VAT. And if you are the individual, not company, you create some IP assets, some intangible asset, and then you sell or swap to the company as a capital. The company law allowed to do that, and the tax law say yes, you can do, but it means that you sell your IP asset to the company, and the company will book in the balance sheet as the asset, and you will be the shareholder. It means that a shareholder, as the owner of the IP asset, sell the IP asset to the company. The individual or owner of the IP asset is required to pay personal income tax. That's why we discuss on the basic of taxation in Thailand. But you know, for the IP and share swap agreement, you can draft the contract, and the individual or owner of the IP asset can push or shift the burden of tax payment to the company. It means that the company will pay tax on behalf of the individual. For example, the valuation of the IP asset 100, tax is around 20. Under the agreement, you can agree by both parties to absorb tax 20 on behalf of the individual. It means that the cost of asset for the company will be 120, right? Okay, why we do that? Because when you when the company transfer the asset, IP asset, at gain, you create more cost, because not cost at 100 but cost at 120. This is allowable or permissible tax planning, just basic tax planning, right? Okay, The other tax will be stamp duty. Stamp duty affixed on the agreement. For example, hire work or service. And another tax is a custom. When you import the machine with IP with the software, the custom department will charge or impose import duty on the IP asset. For example, royalty tax. Right. Okay. Next. The key type tax when you deal with the IP asset or royalty transaction. CIT is a corporate income tax. WHT is a withholding tax. When you deal with a license transfer or when you deal with the licensing agreement in Thailand, it is subject to 3% withholding tax at the time of payment and VAT. Okay. Next, this is the financial statement when you set up the company and you use the IP asset as the asset of the company. The upper line is the balance sheet. The IP asset will be booked as the asset and amortization, similar to depreciation, deduct each year under the accounting period and the tax year. Right. Okay. I will focus on this slide, the last slide for my presentation. The valuation is a pain point. It's a pain point of the IP developer and IP operator. You know Escola. Escola owned by Samsung, SSC. Samsung Corporation is a listed company in the Thai stock market. Samsung in the past manufactured Pepsi for Pepsi Cola and manufacture and distribute. After a long time, many years ago, Samsung and Pepsi, they break the deal, and Samsung now under the umbrella of Thai Bev. But Samsung, no brand, no logo, just water, crystal water, just water, but no brand, black water. Then Samsung create a new brand. We know now Ace Cola or Ace. Many brand in Thai in English, and Samsung create and develop brand for 24 months or 2 years, then sell it out to Thai Bev with the valuation of 1.5 billion baht. Brand for the aging of 2 years. Why 1.5 billion? Different from Ichitan, Ichitan, right? Ichitan Kuntan. Ichitan purchase Baile. Baile? Fruit juice, orange juice. If you know Baile, we are the same age. We are now over 50, right? Right, Professor Sarada and Professor Anongrat? Yeah, we are the same age. Ichitan purchased Baile around 250 million. The aging of Baile brand around 70 years. But why 250 million baht? Different from brand aging for 2 years, 1.5 billion. Different. The key issue is the valuation. The key issue is the valuation. Valuation is SC of Samsung. Now under the umbrella of Thai Bev, because passed through the shareholding. Thai Bev own or hold shares in Samsung around 60%. And then after 2 years, Samsung transfer or sell the brand to Thai Bev with 1.5 billion baht. How to manage the tax on this billion baht income? how to. This is the finance game and tax planning game. Because Samsung set up its subsidiary company in Hong Kong. In Hong Kong, we call Great Brand Company. Great Brand Company is a branding company in Hong Kong. But you know, Great Brand Company in Hong Kong derive income from Thai wave 1.5 billion without tax in Thailand or in Hong Kong. No tax in Thailand, no tax in Hong Kong. This is a tax planning and financial game. Financial game because you know now Samsung manufacture, produce Ace Cola under the brand owned by Thai Wave and pay the trademark license fee to Thai Wave. We can call this transaction like save a lease back. Save it out, develop 2 years and save it out to Thai Wave, the parent company, and then lease it back. But you know, when we discuss on the lease, we discuss on the tangible asset. Tangible asset. But in this case, trademark is intangible asset. Is intangible asset. Then we can say save it out and license back. License back. This is by law. This is permissible by tax. Permissible by tax because Thai Wave now is registered and listed in the SGX or stock market in Singapore. And Samsung SSC listed in the Thai stock market. This is transparent. This is tax planning, pure tax planning. Okay, and cash keep outside Hong Kong, cash keep outside Thailand, but cash keep in Singapore because Thai Wave is a register in the SGX stock market in Singapore. Okay, go back to another case. Another case is Symphony Software. This is around 20 years back. 20 years back, Symphony Software is a software developed by the Thai guys, a group of Thai developers. SME Bank evaluate the value of Symphony Software around 50 million baht. What is the function of Symphony Software? If you can recall, go back to 20 years, you know a ringtone from your mobile phone or wedding call. This is the music. Symphony Software is a software who collect and arrange the license-free copyright. Music is a copyright as a part of IP under Thai law. And then SMB Bank, okay, evaluate the value of software 50 million, and then the company can use the Symphony Software as collateral. As collateral for financing, make a loan from the bank. This is good for you if you are the SME or startup and you have the IP in your pocket, you have the IP in your lab house. Right, okay. The key point for the last discussion today or this morning, I will discuss with you for the startup. If you have the people, how to evaluate the people valuation? How to? No revenue approach because you have no future revenue from the people. Past performance, just startup, you have no past record. Just startup. Or market, you cannot find out the market comparable benchmark from the people. For example, Jack Ma, who knows, or Steve Jobs, or Mark Zuckerberg. This is just a new thing in the world, how to evaluate the people performance. This is a big issue in the finance, the tax, and the legal way, how to evaluate. Just discussion, just negotiation. This is a big issue in the market when you involve in the startup marketplace. Okay, this is my slide. Any questions?
Thank you very much.
Yes,
it's very interesting, Khun Chinapat. I would like you to talk to us 2 hours more about the tax.
Oh, I
Yeah,
have
yeah.
many questions. I
I
have
can
many questions.
yeah, I can grab the I can grab one important thing to student, though, you know, don't forget to add tax to your cost. I think this is very good point. However, you know, something that I would like to be clear, because in my experience, when I make a patent and then someone are interested to buy my patent and the IP Jula, people will call me, Ajahn, can you evaluate your patent for me? I said, wow, how? So can you have suggestion on this last slide? I know that valuation is depending on market alone, but you said revenue and cost also. Can you elaborate more clearly on this? Thank you.
Okay, thanks, Professor Sorada, for your good question. In terms of revenue approach, you can foresee in the future, and in terms of finance, they discuss on the future revenue. It depends on what the aging of your IP asset. For example, 10 years, 20 years. You can imagine it. Okay, 20 years make money, how much? 10 years generate income, how much? And then you can use the future revenue for example, 10 years, you can make money around 10 billion, 10 billion, 10 billion. And then you can calculate back with the financial formula, discount cash flow DCF. For example, 10 years in the future, make money 10,000 ล้าน or 10 billion baht, and then you calculate back discount cash flow to agree on the cash present value now, and
Yes,
then you can
okay.
That's right, cash present value. This is a revenue approach, and the second one is a cost approach. Cost approach, this is for the past performance you need to collect and gather the evidence for the cost of development of the IP. For example, lease, for example, the machine and then it will be the cost of the your IP asset, and then the cost of your IP asset will be the valuation. Not much IP asset adopt this approach. They adopt the revenue approach because when we create IP asset, we foresee the future, and then if you foresee the future, you will build the growth story of the IP asset and as a business. That's why revenue approach now very popular in the Thai market and in the international market, especially for the stock market. Right. For the market approach, you need to find out the comparable benchmark. But for IP asset, I don't think that you can find out the benchmark because just the new thing. Right. Yep.
Thank you very much. I think that's about the time we have, because it's almost. But I wish that we can, you know, talk more in the future.
Sure.
Yes.
Sure.
Ajahn Anungnat, how can students doing the quiz? I think you prepared a quiz for our student.
Not sure. Is Piluka prepare the quiz, or do you want to assign anything to the student?
Anything you want to?
How are you going to evaluate? I mean, I can prepare some questions for your quiz, or if you want to give them an assignment, I can also give you a topic. I can do both. I guess it depends on how you would like me to contribute.
The quiz is good. You have the online quiz, right?
Maybe not yet. Right. Or you know, if you want to have a quiz, send me the questions, and then we can put it on the platform that student use. Is okay too. You know, or anything. It's like up to the speakers. It's like if you want to evaluate the student? Did they really listen to you?
So we can
Okay, Kat.
we can give a opportunity for students to review this video one more time before doing the quiz. So
Yeah, sure.
if you want, yes. Thank you.
Sure. Just before we close, I just want to wrap up slightly on IP management. Having explained what IP is and the various types of IP that is related to deep tech entrepreneur startups, I think it's also prudent to wrap it up in the sense that how do you manage your IP? So number one, we've all heard about registration, right? So if you want to protect your IP, you need to have it registered. Number two, do not disclose your IP lightly, okay? There are contractual documents called NDAs, non-disclosure agreements, confidentiality agreements, CAs, that you should sign before any due diligence, any investor investigation, and things like that. Then it comes to, if you're not going to sell out the technology, if you're only going to license it, if you're only going to transfer a certain part of the technology, again, there are legal contracts that deal with these kind of aspects, okay? As Kuntinapat said, there is always the tax issue. I understand that all startups want to start with having some sort of equity based on their blood, sweat, and tears. That unfortunately might not be justifiable for a lot of investors. For example, you might be in a lab and you might evaluate that your IP is around 31 million baht. The investor will ask you, how did you come to that 31 million? Is it in amount of man hours? Is it because of the expenses for the lab, for the research, and things like that? You have to be able to justify that kind of valuation as well. This is talking about a cost approach. But a lot of the time, the professor or the researcher cannot justify this blood, sweat, and tears equity. So it then becomes a problem, okay? So you need somebody with the knowledge, because obviously you're good at research, you're good at thinking about making new technology, but nobody is good at everything, right? So you need other support in other fields to help you with the finance, with the legal, okay? So then lastly is the enforcement of rights. We talked about this earlier, whether it was worth it to pursue, file a claim against somebody who was infringing or violating our rights. For startups, this is actually something that would probably be more worth it to them, because the technology or the research has not yet become commercially, it hasn't really begun to earn anything yet. However, if there is a cutting edge advantage to it, and if somebody does claim or copy or infringe it in some sort of way, even if your research paper, somebody takes the result of your research papers and things like that, you should try to actively enforce your right as the proprietor to that IP. Once the technology does take off, then you don't have so much headache in trying to prove that you are the real owner. Okay, so that I guess is a wrap up. Thank you so much to Kun Maturot. Thank you, Kuntinapat, and thank you the faculty for having us.
Thank you very much.
Okay, thank you so much, Ka. So everyone, please, if you would like to leave, it's okay. Let us talk to students for 1 or 2 minutes after this. Thank you very much. Ka.
Okay, thank you.
So I stop the record now, Ray.
Okay.
Okay. Stop.